to 5, I think. Na?
Hearing list, my lord. Hearing. Part 2, hearing list.
Oh, sorry, in hearing list.
Yes, my lord. Item number 6, hearing
Yes,
list, my
yes.
lord. In
Yes.
this case, my lord, the respondent number 7 was recently impleaded, and I had represented respondent number 7. And I was served the paper book, copy of paper book, just last week. So I need some time to go through it. If this may be taken up after a week.
So you are the respondent number 7 here?
Yes, my lord, newly impleaded. I have just received the paper book, so I need a week's time for preparation. I have taken the consent of the other party.
Okay. With the consent of the other side, the learned counsel. You are Mr.
Victor,
Victor, appearing on behalf of the respondent number 7, submitted that he needs some time to make for the argument, as he has been impleaded newly as a party respondent to the party case. Prayer allowed, list accordingly. Okay.
and since, my lord, I have one fixed item in court number 1. This item 7 may be taken up on some other convenient date, not today.
Item number 7 of
7.
hearing list.
Yes, my lord. I have other fixed item in court number 1 today.
Okay. At the request made by so and so. Okay.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
My Lord, I beg to mention item number 26 of part 1 list, my Lord.
Yes. Item number 26.
Yes, I'm for appearing for respondent in this case, respondent. I've taken consent of the other side, my Lord. So may I pray, today I have some personal problem. So may I pray this matter on 16th of February, 16th February.
You have taken consent of the other side?
Yes.
You are for the respondent.
Yes, my Lord. 16th of February.
And Lordship, I am for the petitioner in this matter, my Lord.
You are for the petitioner
Yes, my Lord.
with the consent of the other side, the learned counsel. You are Mr. S.K. Medi?
Yes, my Lord.
S.K. Medi, the learned counsel for the respondent, paid for an adjournment. Prayer allowed. List the matter accordingly. On 16th of February, we are listing?
No objection, my Lord.
Yes, ma'am. Highly approved.
May I seek your Lordship's indulgence in mentioning item number 9 of part 2 hearing list?
Item number?
9.
Or part 2?
Yes, my Lord. In this matter, the amicus is out of station, so if this matter may kindly be taken up again after 1 week.
Who is here out of station?
The amicus, Mr. Jordan Rongming Thanga.
Acha, for the appellant?
Yes, my Lord.
Amicus for the appellant?
Yes, my Lord.
You are MS?
Lelrin Omi Tsaktsuak.
Hard MS so-and-so, appearing on behalf of Mr. Nakiri Boydu, Jordan so-and-so, for the amicus query, the learned amicus, for the appellant, paid for an adjournment, citing some inconvenience on the part of the learned amicus. Prayer allowed, list the matter accordingly. You have any date or after 2 weeks will do?
Yes, my Lord.
After 2 weeks?
Yes, my Lord.
List accordingly after 2 weeks.
Obliged.
As on a date to be fixed by the registry.
May I seek Lordship's indulgence in mentioning part 2, item number 1, on behalf of Mr. Joseph Lelsan Himarentley, who appears as amicus in this matter, my Lord. If this matter may kindly come up on
Item number 5.
Item number 1, part 2.
Part 2, item number 1. Yes.
My Lord, if this matter may kindly come up on 2nd February, on Monday. I have taken consent from the other party, my Lord.
You are for the appellant?
I'm for the appellant.
Same order. You are appearing on behalf of Mr. Joseph.
Yes, my Lord.
He is also an amicus here?
Yes, amicus, yes, my Lord.
Same order. You are seeking it on 2nd of February?
Yes, my Lord. Obliged.
We are listing it on 2nd February.
May I seek your Lordship indulgence in mentioning part 2, item number 10. I'm appearing on behalf of my senior, who is the learned amicus, and she is under bereavement for the loss of her father. She recently lost her father. If the matter may be taken up after 1 week.
with the consent of the other side, the learned counsel appearing on behalf of Mr. H. Lalmaswari Swami, the learned amicus, and paid for an adjournment stating that due to expiry of his father, he is in bereavement. Prayer allowed, release the matter accordingly after how many weeks you need here?
1 week, my lord.
1 week, everything will be over here? Your any
Yes.
rituals, anything will be after 1 week?
Yes.
Let take 2 weeks then in that
Okay,
case.
2 weeks is
Let the matter be listed after 2 weeks as on a date to be fixed by the registry. Okay.
obliged, my lord.
For admission, item number 1 to 6.
My lord, I'm for the respondent number 3, 7, and 9. We have to supposed to make a payment as per this honorable court order, my lord. However,
So
we need
you are,
some
you
more
are for the
time.
3?
3, 7, and 6 in item number 1. Union of India BRTF in short, my lord.
3, 7 and 6. Yes.
Yes, in item number 1. I received instruction, my lord. I was instructed to pray at least 3 months' time to approval of that award, my lord, for making payment. If I may permitted to place my instruction letter.
Who is appearing for Mr. Rajiv Dua?
I am,
You are.
my lord, Rajiv Dua is not yet included. He's a new incumbent of chief engineer, Project Puskak. However, not formally implemented in this case, my lord.
But he is not implemented, I think, till
Yes,
date.
my lord. He's a new incumbent of chief engineer. However, not yet implemented.
But he has already filed his affidavit, I think.
He was appeared before the court as per
No, affidavit is also filed by him, I think.
filed by the earlier one,
Huh?
the earlier chief engineer.
No, here affidavit of filed by
That
Mr.
was filed
Mr.
as
Dua
per
is also here.
My lord, that was filed as per this honorable court order, my lord.
Huh?
As per this honorable court order, since he was summoned to appear in person before this court, then accordingly our submission has been directed to submit by way of evidence, by way of affidavit.
इसको लगभग नीचे बहुत ऊपर हो गया है. Chair position is also not good. Not finding possible. Oh, sorry. Position of chair is also not comfortable. Position to chair to उठा दियो पाइयो न न नमै न उठा भए लाग्यो पाइयो मोठी दियो আৰু ক'ব নি সো এইটো বহুত ওখ আছে তো অলপমান উঠাব লাগিব চাম মই উঠি দিওঁ চাম उठेगा नहीं तो हम उठेगा तो दोबारा करो इससे ऊपर जाएगा कि नहीं जाएगा पोजीशन इज नॉट सो कंफर्टेबल आया थोड़ा आया ऊपर no it's okay
My lord, if I may, see,
no the
Rajiv
last
Dua,
now see the last order there
White
is on
order, they get
11 13 11
12.
one order was there
uh,
so by that order you were four 12 4 So as per order of 412, you were asked to,
4/12/2025.
now you are appearing for 3, 7 and 6.
Yes, my lord.
3, 6, 7.
Yes, my lord.
No, 3, not 3, 6, 7. 3, 7, 9 or what? You are for the 3,
In
7, 9.
item, 3, 7, and 9 in item number
Yes,
1.
3, 7, 9 you are. So now you need another 3 months.
Yes, my lord. In the last
Why?
occasion, we prayed 3 months. However, we are not allowed 3 months. We are given only 4 weeks only, my lord.
But
Because-
in between the 4 weeks, what is the progress? What is the position
Yes, my
now?
lord, if
Now see, this is contempts out of 2019. Since 19, these contempts are pending.
My lord, as per
Otherwise,
my instruction at Parachi, my lord, the contempt authority may take time due to involvement of various channels are involved for approval, and presently the case is at a Ministry of Defense. That is why there is a various channel for finalize, my lord.
So for finalization of the award that or the court order for the complementation of the court or compliance of the court order, you need now since 19 it is pending. So that means say now 5, 6 years have already been gone. So till now you are not in a
No,
position.
19 is not gone, my lord. We are praying 90 days. However, we are
No,
not
no,
allowed.
5, 6 years are already gone. That's what I'm saying. That contempt petition, if you calculate.
Well, my lord, final decision has been has been made recently, my lord. Even that case was
Why final decision is being made recently, so
May
recently?
2025 only by the joint spot verification team, my lord.
Spot verification is already done?
Yes, already been now. They're done now.
Who are for the appellant? You are.
My lord, in this case, my lord, as can be seen from the last order, 4/12/2025, my lord, the respondents were supposed to give the up-to-date instruction regarding compliance of the order, my lord. So, my lord, they have been seeking time, as your lordship had noticed, that since 2019, and now they are seeking for another 90 days time, my lord. Only when these court pass strict order by closely monitoring the steps taken by the respondents, they were taking positive steps. So, in spite of the fact that the submission of my learned friend is that they have been taking steps, my lord, let it be taken up after 2 weeks. After every 2 weeks, let them give the updated report, my lord. Otherwise, they were circumventing the direction of this honorable court and delaying the matter.
No, obviously.
My lord, in the last occasion, we are awaiting the correct distance, radial distance and map from the state, from the DC. Then we are still awaited.
My lord, I'm standing on behalf of my senior, Mrs. Mary L. Kiengte. Since she is on leave, as per her instruction, we have sent a letter to Deputy Commissioner Siaha District on 4th December 2025. However, the letter has not been received yet by the Deputy Commissioner.
What?
And
What had not been received?
the letter which we have sent.
Letter?
Yes.
Huh.
After
The letter you have sent to whom?
the Deputy Commissioner.
Huh.
After inquiry, it appears that the letter has not been received till date, and it may be a lost mail. Therefore, I kindly oblige you, oblige your lordship to grant me another 2 weeks to take necessary actions regarding.
No, being the deputy commissioner, you have sent the letter, whatever. Now, what the deputy commissioner has done till date? Is there any report from deputy commissioner? What is the status?
Your Lord, the letter was regarding steps taken we are directed by this honorable court to obtain instructions as to furnish the boundary map of the urban area of Siha and the multiplication factors, etc.
No, last occasion, that is on 4/12, we were instructed to take instructions from the respondent number 1 and 2, that is Deputy Commissioner. But till date, you could not receive any instructions from the Deputy Commissioner or what?
No, we have already received.
No, you took the initiative, you sent the letter.
Yes.
Now, what is the result from what is the report from the Deputy Commissioner? Is there any?
Ma'am, Your Lordship, we have sent the letter, but the letter is not received by the Deputy Commissioner.
Why? Why it has been received?
Maybe, Your Lordship, it may be lost on its way.
Lost?
Yes.
Letter
Because-
is lost?
Yes.
Submitting. Heading. No, itu pertama. Appellant apa ni? Appellant. Petition. Huh? Itu কি হল? না বাজা, ওগুলো মিস। Now he will be the respondent number 12, I think, na? Mr. Rajiv Dua or what his name? I don't know.
He's yet to be
Yet
implemented.
to. Our good item on so also heard. MS. You are Mr.
Daniel Shase,
Daniel Sase, appearing on behalf of
Mrs. Mariel Kiangte.
Mrs. Mary, so and so. Also heard. MS. It I say nam to. Fully, the learned counsel appearing for the respondent contemner 3, 7 and 9. Full stop. Next prayer, it is submitted by Mr. So appearing on behalf of respondent contemner number 1 and 2 that in compliance with the order dated 4/12/2025, the learned counsel has already sent the letter to the DC seeking instructions, but till date they have not received the instructions, and from the necessary from the available information it is learned that the letter is not being received by the DC till date. Accordingly, he submitted that he needs 2 weeks time to file the report from the DC concerned. Respondent contemner number 1 and 2. MS so-and-so, the learned counsel appearing for the respondent contemner 3, 7 and 9 and submitted that they have already done the spot verification. So spot verification has already been done, but to the respondents need 3 months for the payment of the payment as per in person to the order of this court. In that context, Mr. So-and-so, the learned counsel for the petitioner, submitted that that they have made the spot verification only after the order of 4/12/2025, and accordingly he submitted that 2 weeks time may be given to the respondent number 3, 7 and 9 for submitting the report or the report or the necessary instructions. Next para. Further, it is seen that from the office note, it is seen that though one Rajiv Dua has already filed his affidavit in opposition, but he has not been made party to this case till date. Accordingly, the petitioner is hereby directed to file necessary interlocutory application for implement of Mr. Rajiv Dua as a respondent number 13 in item number 1, and the respondent will likhol naam to na respondent in the all the contempt petitions. Full stop. Next para, however, considering the submission made by learned counsel for the respondent number 1, 2, 3, 7 and 9, 2 weeks time is hereby given for
Compliance.
submitting report,
Submitting the updated report and for compliance of the order.
submitting the report. Comply 2 weeks, most probably it may be not be sufficient for them. In that case, let it be after 4 weeks then,
Let it be 2 weeks as you
till
please.
date. Now, you do one thing, as you have submitted that you need 3 months time, that is the 90 days. But it may be, again, it may not serve the purpose. So do one thing, after 2 weeks you submit the report, then what you have
My
done.
lord, now we are still awaited the clarification from the DC. That is one of the main reasons, my lord.
No, you give all the details in your report, and in the meantime, the respondent number 1 and 2 also give us the detailed report, what they have done in regards to the verification report and what they have submitted. Because otherwise, if it is listed after 4 weeks or 3 months, it will again create some problem. So let us give the report first.
In that case, my lord,
Uh,
if I may, let the DC also file the affidavit updated report.
Yes, yes, DC also.
Because they are waiting, the central government are waiting for the instruction to be submitted by the DC.
Hmm.
But till date, even after 1 month since the last court date, the DC, they have not yet obtained any instruction.
Expert, in view of this, I let the respondent number 1 and 2 oblique the deputy commissioner to submit the verification report, and in compliance of order dated, in compliance with the order dated 4/12/2025, and within 2 weeks they will submit the report of verification also. Further, the respondent number 3, 7 and 9 is also hereby directed to submit his report of compliance within 2 weeks from date of order. You need a date here or after
Yes,
2
my lord,
weeks?
let the date be fixed. Tenth of February.
Yes, 10th? 10th of February may not be,
12th,
let it be on 12th of February. Yes, 12th of February.
deeply obliged.
So whatever report you got, just give us the report, and as a respondent number 1 and 2, you are also instructed to submit the verification report to the government concerned respondent, so that they can act upon then that report, and compensation can be given within 3 months. That is the decision. Okay.
Obliged.
1 to 6 already, right? In the meantime, you also take steps for implementing him as a party, because he has already filed his
Yes, your lord.
affidavit in opposition.
Item 7 to 10.
Yes, in item 7 also,
My lord, the similar matter, under the same award, my lord. Same prayer.
here also same prayer, I think.
Yes, same prayer, but I am a defendant is different only. The holding cost of different
Pardon?
respondent are different only.
Pardon? Here also you have not
Respondent are
received, you
different
have not
only.
received the verification report.
Yeah, we are still awaited the clarification from the DC.
That the
In each of the
clarification report is
cases.
still awaited.
Yeah,
My lord, verification was already done 5 years back, and they have already made the assessment. That was also already approved by the state government, but they were seeking some clarifications on some points. Only that is awaited.
So, what about you? Why the clarification is not, could not be submitted?
Ma'am,
That the clarification, verification as is submitted has already been done. Now they need some clarification from your side.
Mr. Lordship, it is if same order can be passed We have sent the letter. That letter which we have sent. The same order can be passed.
খালি ইমপ্লিমেণ্টৰ কথাটো এৰি বাকীখিনি মোৰ লেছ একেই হ'ব খালি ইন ডেট কেছ ইন দিছ কেছ ইউ আৰ ৰিপ্ৰেজেণ্টিং দ্য ৰেছপণ্ডেণ্ট নাম্বাৰ
Respondent number 2, 6, 9, and 12 in item number 7.
Two, 6, 9, and 12. And you are, as a Deputy Commissioner respondent, you are appearing for
15.
15.
1-5.
Yes, on behalf of my senior.
Yes. এইটো এটা খালি চেঞ্জ হ'ব এইটো ডিসি রেসপন্ডেন্ট হৈছে রেসপন্ড নাম্বার 15 আর 269 হৈছে স্টেট রেসপন্ডেন্ট আৰু অকল রিপোর্ট টু ডিফারেন্স হ'ব যে দে আর এৱেইটিং ফৰ দি ক্লিয়াৰিফিকেশন রিপোর্ট ফ্রম দি ডিসি কনসার্ন সেইকাৰণে কমপ্লেইন্স কৰিব পৰা নাই and from his submission from respondent number 15 it will be his submission that they have already sent the letter to the DC seeking the clarification report but till date it has not been received and according to 2 weeks time a same report so we, in that case also only the clarification report
Yes,
is
my lord.
required
Yes,
here
right.
for the respond number 2, 6, 9 and 12 for compliance of
Yes,
the order
Yes, my lord.
so within 2 weeks you submit the report
Yes.
clarification report whatever
Yes, my lord.
or what is the instruction anything within 2 weeks 2 weeks we are listing in same date on 12th of this February and you submit the clarification report on that invariably without fail so that the complaints can be given by part by 2, 6 and 9 okay
Item number 11.
it is 6 to 10 it is one is 6 to oh sorry 7 to 10 yes this is item number yes what is the position of item number 11 here
My lord, similar prayer, same, all are under the same award.
all are under same award
Yes, my lord.
in this case you are the respondent number
Number 7,
3, 7 and 9 I think
2, 6, 9, and 12.
no in the last order you are saying the 3, 7 and 9 no not 3, 7 and 9
In item 11, my lord,
in item 11 you are the respond number
2, 6, 9, and 12.
2, 6, 9 and 12 and yes Deputy Commissioner is
Respondent number 4, 8,
4,
10,
8,
13 and 15.
4, 8, 13 and 15
4, 8, 10, 13
4,
and
8, 10
15. 13 and 15.
13 and 15 it looks of state respondents state respondents contempt 2, 6, 9, 12 and 4, 8, 10, 13, 15 here also you are for the petitioner no?
Yes, my lord.
So what is the position here in this case same position
Same, my lord.
here also you need the clarification report or
Yes,
what
my lord, same. All are same.
So now see, these are again, I'm just saying that these are all contempt cases for 2019. So if any adverse orders goes against all the government, the state respondents, it will not send a good message to society also. Because the court's order, you have not challenged the court order, that earlier order. So you are bound by the order. Please do it within time. After 2 weeks, if just submit a report, if there is sufficient compliance of the order, then another 2 weeks we may give, so that full compliance can be given or the money can be, compensation can be distributed. Otherwise, it may not be so proper. Same order. Okay. So in all these cases, we are listing it on 12th of February, asking them to submit the clarification report from the DC concern or from the DC promoter.
Item number 12 to 15.
Similar order can be passed, my lord.
Same order may be passed.
Same.
Yes. Till item
So
number-
how many, in fact, there are many matters, I think.
Because council is, in some cases, council is different, that is the reason.
Council is different means?
This is the petitioners herein were belonging to same stretch of road from different village. And they were covered by the same award, one common award.
Huh.
Now,
This was for the construction of
construction of road
road. no?
undertaken by the BRTF. And
But the last order I have seen, there I have gone to the record. So as per your instruction, whether the road has already been constructed, not yet constructed, what is the position?
now they have already constructed,
Constructed, not
Already
yet
done.
constructed,
already done.
already done.
But the petitioners were denied of their legitimate entitlements.
Let's say in spite of the order, which is a very strict order passed by this court on 4/12, I think. No, not on 4/12, 13/11, whereby the personal appearance was also asked for. But in spite of that, matter was listed on 4/12. I relisted here, so we are not passing that order. But the question is that compliance is necessary. Same thing. Otherwise. Because if you go by the order of 2025, 11 order, I mean November order, in that case you were asked to the project, the chief engineer, the project Pushpak, and Mr. Sudhakar Sharma, assistant engineer, they were asked to appear personally before the court, in fact, on is part to order of the 13/11/2025. But in spite of that, the matter was listed on 4/12, but most probably that was not insisted. Whatever, now what is the position? Same position. 2 weeks time we will giving for the report and all what? Can you submit the report, whatever compliance has been done within 2 weeks? Okay? Yes, anything to submit? You want to submit anything? Want to submit anything here?
My lord, if the request to verify has been verified by the state, it may be easier to process the matter also, my lord.
Verification is not yet done here in this case?
My lord, if I may, that affidavit filed by Rajiv Dua, that was filed on 9/12/2025. That the letter has been sent to DC. That is at Annexure 2, Annexure 2 and 3. Then Annexure 2, 3 and 4, we are still awaited that clarification from the state. Then it seems that there may be likely to make a correction also, however, we are still awaited.
Do you have any instruction in this case? Otherwise, all the matters are same, I won't say. Here also same submission, that he has not received any letter?
No, we haven't received any letter, Your Lordship.
Huh?
We haven't received any letter, Your Lordship.
No, but from your concern, that letter which has already been sent to the DC, he has already received that one?
Your Lordship, regarding that letter, which was sent on 4 December 2025,
Huh.
the letter seems to have been lost because, Your Lordship,
No,
I
in
think-
all these cases, you are saying submitting same thing, then letters is lost. Now, what you are going to do then?
Your Lordship, we'll be resending the letter today, if
Ah.
Your Lordship kindly permit us.
Huh.
And we will
You
also...
you will be sending the letter today, then within 2 weeks, will be there possible for giving any clarification report, whether verification was done or not, whether clarification report can be prepared within 2 weeks. These are the questions to be seen, na?
Yes.
Now, done. You are saying similar submission that it has been lost. It is lost is not so matter, na. Through communication, through telephonic communication or other mode also, you could have communicated with the DC. What is this in? The court has already asked for the clarification report because the other respondents are repeatedly saying that that as they are not receiving the clarification report from the DC, they could not comply this report. Then in that case, to definitely you, from your side, clarification has to be there. So will it be possible within 2 weeks for the submitting, because there are many cases I have seen, many matters are there. Do it, otherwise see how to do. That's why we are giving 2 weeks only, so that at least you give the report, what they have done, what is the stages, and report is not so report that simply verbal submission will not do. That we are doing this, the entire report has to be there. How many clarification has already been done in all the matters. Now 1 to 6, then again 7 to 11, then again 12 to 13. These are the matters, same kind of matters, out of same compensation and all things. So what progress you have done, just step by step you have to give, yes. How many the clarification has already been done, what is the report has already been submitted, what is the stages going on. Report has to be in detail. It is not a case that you are submitting simple verbal submission will not do, I am just repeating. Understand? You don't give the only verbal submission from the DC concerned that they are doing that. It's not me. Just give the report, compliance report in a very specific form.
Yes, my lord.
You give the detailed report.
Yes, ma'am.
What is the doing, what is the stages, how it is going, what is the clarification report, whether it can be completed within 4 weeks, or this can, everything has to be there.
Yes, my lord.
Detailed report. Simple verbal submission that we are not taking, and this will not do. Huh? Here also you are appealing for whom?
Mrs. Mariel Kyangte.
Huh?
Mrs. Mariel Kyangte.
No. Appealing for whom? No, sorry. The respondent numbers?
Respondent number 4, 8, 10, 13 and 15.
Same. 4, 8, 10.
Yes, Your Lordship.
4, 8, 10.
13 and 15.
13 and 15.
Your Lordship, in item number 12,
Ah.
4, 7, 8, 10, 13 and 15.
4, 7, 8, 10, 13 and 15.
Yes, Your Lordship.
And you are appealing in item number 12?
I am for respondent number 2, 6, 9 and 12.
2, 6, 9 and 12. Okay, we are passing the same order here also, but eta khali line likhi dibo je that detailed report lagibo. The detailed report has to be submitted by both the respondent contempt number so and so, duita dibo. Clarification report, you to duita report. You submit the clarification report to the department concerned so that matter can be expedited.
Yes, my lord.
All the matters we have listed on 12th of February. Some results should be there. Simple submission that a letter has been lost, this kind of don't make this kind of submission. Okay.
Item number 16 to 25.
My lord, I am for the petitioners here.
Just a second. 16 to 16 to 25, all these are the revision dates. All are.
All are revision.
Now these are not connected or what? Is it connected?
Not connected, same subject matter,
Same
but
subject matter, okay. Connected no hoy kintu.
My lord, in item number 16, as per the last order, we are waiting for respondent number 2 and 4. The for respondent number 3 and 7,
The respondent number 1, 5, 6 and 8, they have already filed their affidavit.
they have already filed
Only
affidavit.
10 is yet to file their affidavit and service is awaited for 2 and 4, isn't it?
Yes, my lord. Yes, my lord. And we also are in the process of awaiting approval from the department for filing the rejoinder. We have sent a draft, my lord, so we are waiting for the approval.
You are going to file rejoinder?
Yes, my lord.
Rejoinder affidavit also? Okay.
Yes, my lord.
Now, yes, respondent number 10, who is appearing for respondent number 10? So, you are going to file affidavit today?
I have not yet received instructions from the respondent number 10.
Not receive instructions?
My lord.
And what the office report says? Service is still awaited. Now see, for the respondent number 2 and 4, the service is still awaited. So do you have any
Yes, my
other
lord.
source why service is awaited for respondent number 2 and who is 2?
To the private respondent, my lord. Both 2 and 4 are private respondents.
2 is Sri so and so.
Khong Tua, my lord. And respondent number 4 is Lalbia Thwami. They are the residents of Kolasip district.
So for them to service is still awaited. Do you have any proper or present address for these 2 petitioners? I mean respondents? Otherwise,
My
we
lord,
are awaiting for service till next date. But if you can get the proper address of 2 and 4, just collect it. Otherwise,
All right.
service is still awaited. Okay.
All right, we'll try to find out, my lord.
You are Mr.
Mr. T. Marngar, my lord.
T.
T. Marngar.
Heard Mr. T. Mangal, the learned counsel for the petitioner, and also heard Miss. Yes, MS. You are appearing for respondent
I'm
number
appearing for respondent number 1, 5, 6 and 8.
1, 5, 6 and 8.
Yes, Miss Rosie.
Miss Rosie appearing for 1, 5, 6 and 8, and also heard government respondent. Na? Respondent number 10, you are appearing.
Yes, my lord.
Responding, your good name?
Caroline K. Lungoipui.
So and so. Your state respondent, na?
Yes, my lord.
State respondent number 10, so and so appearing for the state respondent number 10, and also heard. You are for? She is for?
My lord, I'm appearing for item number 17.
Item number?
16. Now item 16.
Oh, 16. You are 17 only. Okay, okay. So and so. From the office note, it is seen that the service is still awaited for the respondent number 2 and 4. Let the service be awaited till next date of listing. Further, the MS so and so, the learned counsel state appearing for the state respondent number 10, submitted that the instructions are yet to receive from the respondent number 10 to file their affidavit in opposition. In the same time, Mr. Manga, the learned counsel for the petitioner, submitted that he also needs some more time to file their rejoinder affidavit. Prayer allowed. Let the matter be listed. You need any fixed date here?
It can be on 23rd of February, my lord.
Okay, 23rd of February 2026.
My lord,
Interim was there.
Interim was there, my lord. It can be
Interim will
extended.
be continued till next date of listing. Okay. In item number 17, who is appearing? You are for the item number 17 also, I think.
Yes, my lord, we are petitioner, my lord. My lord, in this case,
I'm appearing for respondent number 1, and I have already filed an affidavit in opposition.
Lordship, I am appearing on behalf of the respondent number 2, and I have received the vetted parawise comments. I will be filing within 3 weeks.
Here also you are for the petitioner?
yes, my lord, I'll be filing my rejoinder in this case, so my lord, we're just waiting for the draft to be approved, my lord.
Same job, 17 or to same job, heard Mr. So-and-so, the learned counsel for the petition. and also heard. MS, your good name?
Lalrid Amit Lau.
MS so-and-so appearing for the respondent number 1, who has already filed his affidavit, her affidavit in opposition. However, MS so-and-so, the learned counsel for the state respondent number 2, submitted that they have already received the instruction. You have received the instructions, yes, instructions, but need some more time to file their affidavit in opposition. Prayer allowed. In the meantime, Mr. so-and-so, the learned counsel for the petitioner, also submitted he also needs some more time to file their rejoinder affidavit. Here also, interim is operating.
Interim is there, my lord. Interim is there.
We continue till next date of listing. List the matter accordingly on 23rd.
We can be
23rd of February 2026. Same order, I think, for
item number 13, item number 18, my lord.
18 also,
all
who is
for-
appearing?
I'm appearing for respondent number 1 to 10, my lord. And we have filed our affidavit in opposition.
You have already filed?
Yes, my lord.
Take it 1 to 10 okane ase, in item number 18, 1 to 10, and already filed their affidavit in opposition. So here also you are appearing for state respondent number?
11.
State respondent number 11? 11 is, You have, here also you have received your instructions or yet to receive? Not yet received. Same order, not yet received the instructions and needs some more time to file their affidavit in opposition. Here also you want to file your rejoinder? Rejoinder
File a
affidavit or kind of same prayer. And interim was there earlier?
Interim was there, my lord.
Interim we continue till next date of listing, list accordingly on 23rd of February 2024. And in 19, item number 19, who is there?
Yes, in item number 19, my lord, I'm here for the respondent 1, 2, 4 to 8, 11,
Just a second. 1, 2,
2, 4 to 8,
4 to 8. Okay.
11 to 22,
11 to
22,
22.
24 to 33,
24 to 33.
35, 36, 41, and 44 to 51, my lord.
And 35, 36, 41 and 42 to?
41 and 44 to 51, my lord.
44 to 51. So I said 1, 2, 4, 4 to 8. And 4, 5, 6, 7, 8. 11 to 22. 24 to 33. Then 35, 36, 41. And then 44 to 51. You have already filed your affidavit?
Yes, my lord, we have filed.
Filed police affidavit in opposition. Here also your state respondent number? 52.
52, my lord.
Instruction is yet to received. Instructions are yet to be received. Time, Nico. In that case also you are going to file your affidavit, rejoinder affidavit?
Yes, my lord. Yes, my lord.
Same-
And
same.
in this item, my lord, there are certain respondent which notice has not been served, my lord.
Yes, just tell us, which are the numbers?
As per the last order, my lord, 1, 3, 9, 10, 23, 34, 39, 42, and
No,
43.
just a second. One, they have already appeared.
Yes, one they have already appeared. So
So now
Directly-
service is awaited for 1. No,
For
sorry, not 3.
three-
3,
3, 9, 10,
3,
20,
9, 10,
23, 34,
23,
30,
23, then
34,
34, yes.
39, 42, and 43, my lord.
39, 42, and 43.
43.
3, 9, 10, 23, 34, 39, 42, 43. Service is awaited. Service be awaited till next date of listing. Rejoinder prayer to allow Koidipo. Interim be continued till next date of listing. List accordingly on 23rd of February. So it's. And what about this 20?
Item 20, my lord, all respondent represented, my lord.
All respondents have appeared.
And
Yes,
I'm for
ma'am.
the respondent 1 to 5, my lord, and we have
In
filed
item
our-
number 20, your respondent
1
number?
to 5,
1 to 5.
and we have filed our affidavit in opposition, my
You
lord.
have filed your affidavit in opposition. And state respondent is? Respondent number 6. You have already filed? No. Yet to receive instructions. Same order. So here you have respondent numbers up to 6 only? Yes. 1
Yes,
to
my
6?
lord. 1 to 6.
Okay. Same order. Service is not abated for anyone, all have appeared. Okay.
Yes, my lord. Interim may be continued in this
Interim
case,
be
my lord.
continued till next date of listing, 23rd of February 2025. Okay.
Deeply obliged.
In item number 21, my lord, all respondent is represented, my lord. The private respondent has already filed their affidavit. In this
Item
case, my
number
lord,
21, what is the position?
all respondent are is being represented, my lord.
All respondents. So you are
Yes.
for the respondent number?
Number 1, my lord.
1, you have already filed?
Yes, we have already filed an
You have already filed your affidavit. Now, state is for?
Respondent number 2 is state, my lord.
2 is state. Only 2 respondents are here?
Yes, my lord, only 2 respondents are there.
Here also you need time for affidavit,
Yes, my lord.
rejoinder affidavit. Okay.
Yes, my lord.
Was there any interim here also?
Yes, my lord. Interim is there, my lord.
Interim was there. Okay. Same order, bro. Interim was there, 23rd of February. Okay. Now,
My
what is
lord-
the position in 22?
In item number 22, my lord, there are certain respondents whose service is not complete yet, my lord.
Service is completed on all respondents?
No, my lord. There are certain respondents whose service is not completed as per the last order, my lord.
22 to deposit.
My lord, as per the last order, respondent number
You are for
268.
1. You are for 1? No. Item number, what is the item number? What about the item number 22?
22, my lord.
In 22?
In total, there are 65 respondents, including the state respondent, my lord.
You are not the respondent number 1? 65. 1 has already filed. The respondent from the office note dated 22/01/2026, hard দিব প্ৰথমতে hard Mr. T. Mancha, so and so for the petitioner. From the office note dated 22/01/2026, it reveals that the service is still awaited for the respondent number 2, 6, 8, 9, 10, 11, 16, 19, 21, 25, 26, 29, 32, 34, 36, 37, 38, 39, 43, and 44. One has represented the respondent number 1 and the other respondents whose service is already completed. However, from the record, it is seen that the respondent number 1 has already filed his affidavit in opposition. So, respondent number 1 had only filed his affidavit in opposition. Do you need any time for here also you are going to submit any?
Yes, my lord, we'll filing our rejoinder also, my lord.
Also heard Ms. So-and-so appearing the state respondent number 65 and submitted that you have instructions you have received here? Submitted that she has not received the instructions to submit their affidavit in opposition.
My lord, as per the last order, the state has made a submission that they will not be filing affidavit, my lord.
Who is not going to file?
The state respondent will not be filing the affidavit. It says
No,
submitted
but
on.
they are now saying that they are going to file. Na?
Right, my lord, right.
So 65 you are appearing, na? For state respondent 65 you are appearing. Same orders, video, so and so. Our service be awaited for so and so corridor. Rejoinder affidavit or kind of prayer to allow corridor. Interim be continued till next date of listing. List accordingly on 23rd of February 2020. Okay.
Okay. My lord, next item would be
23.
23. Oh, my lord.
Yes, in 23, what is the position?
23, my lord, notice are completed, but certain respondents are not represented on the last occasion, my lord.
23.
The represented private respondents already filed his affidavits.
So you are here 6, you are?
Yes, madam, 6. State will not be filing in this case. They will not be filing our affidavit.
Not be filing. Last occasion also you have submitted.
Yes, my lord. My lord, in this, we will be filing our rejoinder to the already filed affidavit by the private respondent, my lord.
No, but they have not filed any affidavit now till date.
Respondent number 1, I believe, he has already filed, my lord.
Acha, one has already filed, yes. One has already filed. Heard Mr. Swenson, the counsel for the petitioner. From the order dated 12/12/2025 as well as from the office note, it is seen that the notice on the respondent number 2 to 5 has already been completed, but no one has represented it. In the same time, it is submitted by MS So-and-so, the learned counsel, appearing for the state respondent number 6, that they will not be filing the affidavit. Full stop. MS Mr. So-and-so, the learned counsel for the petitioner, submitted that some time is required to file their rejoinder affidavit. Prayer allowed. List the matter accordingly on 23rd of February 2025.
Interim also.
Continued till next date of listing.
My lord, in item number 24, there are in total 36 respondents, my lord. 37 respondents, my lord. We were certain respondents whose service are still awaited, my lord.
24. Here your state is the respondent number?
State is 37.
37. Yete baki order same thakibo. Here you are going to file or no? Yete file na kore yate same order. 26 is still awaited. No, sorry. The service for respondent number 1, 2, 4, 5, 6, 8, 10, 11, 12, 13, 29, 31, 32, 33, 36, and 26 are still awaited.
He also, my lord, will be filing the rejoinder to the already filed affidavit, my lord.
Who filed your this affidavit here?
My lord, here,
3 or otherwise? Who has filed? No one has filed, I think.
As per the affidavit, my lord, is respondent number 4 who has filed it, my lord. Respondent number 24, I believe, my mistake, my lord.
Time to reach আপনি দিদিও খালি রিজয়েন্ট এফিডেভিট ওখানে এটা বড় উল্টা পুল্টা হয়ে গেছে আর সার্ভিস টু কার কার কারণে ওয়েট করা আছে দিয়া আছে না রিজয়েন্ট এফিডেভিট ওখানে টাইম সার্ভিস দিও আৰু স্টেটে নকৰে ফাইল নকৰে will not be filing for the state respondent আৰু বাকি interim be continue till next date of listing list accordingly on 23/2.
My lord, in item number 25, service is complete upon all the respondents. The private respondent has already filed their affidavit, my lord.
Services
we'll be
completed for
filing
all
our rejoinder
services
also in
completed
this
for all
case.
respondents here.
Yes, my lord.
Services completed for all respondents.
Yes, my lord. There are 2 respondents. Yes,
Only
my
2
lord.
respondents. Okay.
There are 2 respondents. One is private. My lord.
State going to file? You're not going to file. Only 2 respondents, Sir Khali. You here state is 2 or 1? Respondent number 2.
2 is a state, my lord.
Hard so and so, state respondent submitted and then we will file in affidavit. However, the learned counsel for the petitioner prayed for some time to file the rejoinder affidavit, prayer allowed. List the matter accordingly on 23rd of February, so and so. Interim be continued till next date of listing. Okay.
Item number 27 to 29.
My lord, in item number 27, my lord, we are still awaiting service on my lord. On respondent number 1, we are still awaiting service, my lord.
State is the respondent number with the number? Huh? Respondent number 2.
This number 2.
One is already served, I think, no? Service report is still awaited. So what is the position of state? Are you going to file any? No, not be filing. Hart Mr. T. Manga, the learned counsel for the petitioner. From the office note dated 14/1/2026, it is seen that service report is still awaited for the respondent number 1. However, it is submitted by MS so-and-so, the learned counsel for the state respondent number 2, that they are not going to file any affidavit in opposition. Let this service be awaited till next date of listing. List the matter on 23rd of
My
February
lord, if can be on the same date.
Interim be continued till next date of listing.
Interim.
Yes, his interim was there.
Yes, interim was there, my lord.
Yes, what about
My lord,
the-
in item number 28, respondent number 1 is notice served as unrepresented, and respondent number 2 and 3 is we are still awaiting service on the last occasion, my lord.
So what is the state respondent here? You are going to file affidavit here? No. Heard Mr. M. Manga, the learned counsel for the petitioner from the Office note dated 22/01/2026. It is seen that the service is still awaited for the response number 2 and 3, and MS so-and-so, the learned counsel appearing for the state response number 1 has submitted that they are not going to file their affidavit in opposition. Let the service be awaited for the response number 2 and 3 till next date of listing. List the matter accordingly on 23rd of February 2025. Interim be continued till next date of listing.
My Lord, in item number 29, service upon respondent number 1 is still awaited. There are only three respondents, my Lord. Respondent number 3 is the state, my Lord.
Here,
Respondent number 2 is
3 is
served but
the,
unrepresented.
3 is the state here. So 1 is still awaited and 2 is already
Yes,
served.
Already served, but, my Lord.
Same order, heard Mr. So-and-so, the learned counsel for the petitioner. Service on the response number 1 is still awaited. From the office note, it reveals that service is already completed for the response number 2, but no one has represented the response number 2. MS so-and-so, the learned government advocate for the state response number 3, has submitted that they are not going to file any affidavit. Let the service be awaited for the response number 1. List the matter accordingly on 23rd of February 2025. Interim be continued till next date of listing.
Highly obliged, my Lord.
Item number 30.
Appeal is already admitted, I think. We have received this copy, TCR. TCR has already been received here. Lower court record. Received. Why scan copy? This is a criminal appeal or what? Why we need this scan copy?
It's written like this, scan copy.
But a scan copy will not do. It will call for the TCR because it is disposed of matter, isn't it? So we are going to call for the TCR. Scan copy has been received, but let the TCR be called for.
Yes, Your Lordship.
Because it has already been disposed of matter, in fact. So in that case, we can fix it for hearing.
After calling for the TCR, my Lord.
Yes, accordingly it will be listed.
Paper book will be required.
Prepared, Your Lordship.
Paper book, in a sense, it is the evidence are recorded in the what language? Not in English.
They were in English.
A paper book will be required, no?
Yes, my Lord. Because with all the exhibits, documents and all.
Okay. Heard Mr. Victor, the learned counsel for the appellant, and also heard MS so-and-so, the learned additional public prosecutor. The scanned copy of the TCR has already been received, but it reveals that as it is a disposed of matter, let the TCR be called for, and registry is also hereby directed to prepare the paper book on receipt of the TCR and to list the matter accordingly in hearing call. List in due course. Okay.
Deeply obliged.
Item number 31.
My Lord, the respondent number 3 had entered appearance.
Respondent number 3 already appeared.
Yes, my Lord. I'm for the respondent number 3.
You are for the respondent number 3.
And Your Lordship, I'm appearing for respondent number 1 and 2.
Is a state respondent?
State respondent.
Okay. So it's a case of petition for quashing.
My lord.
My lord, we'll file an objection affidavit, my lord.
You're going to file.
Yes, my lord.
Hard, Mr. You're Mr.
Seetlan Thiang Lim.
Hard, Mr. Seetlan Thiang, the counsel, learned counsel for the petitioner, and also heard Ms. So-and-so, the learned learned additional PP, appearing for the respond number 1 and 2. And Mr. You're Mr.
J.H. Rikil Al Rotfela.
Huh?
J.H. Rikil Al Rotfela.
Nam to Sila Boyapa, so-and-so, appearing for the respond number 3, and submitted that is going to file his written objection. Prayer allot, please do matter accordingly. You need a fixed date, or after 2 weeks will do?
2
How
weeks,
many
my lord.
weeks you need? 2 weeks?
2 weeks.
Please do matter accordingly after 2 weeks, as on a date to be fixed by the registry. List accordingly.
If the interim order may continue, madam.
Interim was there.
Yes, my lord. There's a stay of the criminal
So
proceedings.
stay was there. no?
Yes, ma'am.
Interim be continued till next date of listing.
Obliged.
Obliged, my lord.
Item number 32.
With your lordship permission, I have taken the consent of the petitioner, my lord. If item number 33 and 34 may be upgraded, so that item 33 and 34 may be taken up first, if with your lordship permission, because they're going to have a hearing in bail application item number 32. Since in item number 33 and 34, the respondent will not be submitting any written objection in the IA, if your lordship permits.
No, it is 32 or 30?
Yes. I'm asking for upgradation, my lord.
Oh, acha, acha. 33 and 34?
Yes, my lord.
In 33, one I was there.
IA was there. There was a stay of the execution petition, my lord. Now, this honorable court has passed an order that before granting absolute stay of the execution petition, we have to deposit half of the amount, the decretal amount, to the lower court. Your lordship may be kind enough to see this letter.
So how many LA cases are there?
Now,
5.
in this particular case, the decretal amount is 832818. That is at serial number 4.
8?
832818. 8,32,818. Your lordship will see at the letter serial number 4. Now we have deposited that amount to the district court. Your lordship may come to the check in the next page.
So
That
1
is-
lakh? So you have deposited?
We have deposited in 5 cases. In 5 cases.
Oh, in 5 cases?
Yes.
Acha, acha.
Now this particular case, the decretal amount is 832818, and we have deposited that amount.
That is the 50%?
Yes, that is there, without calculating the solicitation amount. Now this honorable court has disposed this stay in a connected matter in a similar case recently on 21/1/2026. So may I place that order, my lord? this Honorable Court, on appreciation of the amount of money deposited by the government, has stated the execution cases pending before the Learned Reference Court. So if your Lordship may be kind enough to pass an order in the similar line in this board 33 and 34.
So this I is basically for your stay.
Stay of the execution proceedings. There is a connected LA appeal as well, my Lord, which was also taken up by this Honorable Court. So my main prayer is that let the stay application be made absolute, since we have deposited the amount as directed by this Honorable Court.
So in your particular case, this is execution petition is 01/2025.
Yes, my Lord. And the LA case is 15 of 2015.
15 of 2000. Achha.
And the connected LA appeal would be 5 of 2025. Your Lordship may kindly see at page 50 and 51. That is the connected land acquisition appeal.
What number? Page number 50?
50.
Where is the 50?
In the RFA 47 of 25.
Oh, RFA, okay.
Yes.
RFA 50 or 47?
47 of 2025. And the page number would be 50. This is the first order passed by this Honorable Court. And subsequent to that, there's another order, 2011-2025, which granted the condonation, which condoned the delay of 140 days, my Lord.
No, it's delay is already condoned.
Delay condoned.
It's okay.
So,
admitted.
my submission today is that there is also a connected LA appeal along with this RFA, my Lord. That is what I'm trying to impress upon your Lordship. So this stay application.
Those LA appeals are pending before the district judge court.
No, this LA appeal is pending before this Honorable Court. And this RFA is also pending before this Honorable Court. And today, it is our humble prayer that this stay application may be made absolute.
No, but from where from you are saying that item number 4, that is 8,32,000, is connected to this case only?
Yes, it's connected to this LA appeal 5 of 25. That is why I have annexed the order, my Lord.
Yes, do you want to submit?
No, my Lord, we have no objection regarding this.
Regarding stay, you don't have any objection?
Yes. Since the Honorable Court last week on 21/1/2026 already disposed it.
Pardon? What deposit?
This RFA.
In a similar case.
Similar case.
Analogous case.
Anyway, this is also another stay case.
Yes.
Yes, my Lord.
You don't have any objection. What I'm saying that you don't have any objection.
Yes, my Lord.
No. Heard Mr. C. Lakhojwala, the learned counsel for the appellant applicant, and also heard you are Mr.
PC Langthoma.
P.C. Langthoma, the counsel for the respondent. Full stop. And this is an application under 41 Rule 5 CPC for stay of the impugned judgment and order dated 11/9/2025 passed by the learned First Track Court cum Additional District Judge Aizol in Judicial District Kolasip bracket of the Executing Court, and also the order attachment dated 11/09/2025 passed in execution petition number 05/2025 arising out of LA case number 15/2025.
Execution petition would be number 1, my lord.
Yes, 01/2025.
Yes.
Next para, in pursuant to order dated 28/05/10/2025, the present petitioner has already paid the half of the compensation amount of rupees 8,32,818 before the learned executing court, and to that effect the order come certificate issued by the this is issued by whom? The joint director?
Joint Director, Finance and Accounts,
Acha.
Engineering Chief Office,
Issued
PWD.
by Joint Director bracket of Finance and Accounts, Engineering in Chief Office, PWD, Mizoram, Aizawl. And along with this, one the SB account check number is also filed, whereby it is seen that rupees 1,71 lakhs 12,721. You see the figure from here also has already been deposited in connection with 5 numbers of LA Civil, wherein the present case is also connected with LA Civil 189/2025.
My lord, that would be IA. It's a
Oh, it's
typical
IA?
Yeah, it's IA.
Oh.
They have written LA. It has to be IA.
Oh,
civil.
sorry. IA Civil 189/2025. Oh, sorry, this one is IA na, sorry.
Yeah, that's what. They
IA
have
Civil 189/2000, that is the present case.
wrongly mentioned.
Next para, Mr. So-and-so, the learned counsel appearing for the respondent submitted that he has no objection if order of stay has been passed, as the money has already been deposited by the petitioner. In view of this, let the execution proceeding be pending before this court, na?
No, pending before that
First track
court, Colosseum.
execution proceeding, execution petition number 01/2025, arising out of LA case number 15/2025, be stayed. Judgment and order, you just see, in view of this, the judgment and order dated 11/09/2025, passed by learned first track court cum additional district judge Aizawl, district Kolasep, and the order of attachment dated 11/09/2025 be stayed in connection with execution petition number 01/2025, arising out of LA case number 15/2015 till the disposal of connected RFA 47/2025. With the above observation, the present I stands disposed of.
Much obliged.
Now, what is the 50?
In
33? Here also one R is pending, na?
yes. Now in this RFA 49, execution petition number 3.
Here the execution petition number
3.
No. Here I is which one? Oh, sorry.
No,
Just a second.
we can go to item number 34, madam.
No. We are saying item number 34 only.
33. We are at 33, my lord. Just now we are at item 33.
Yes. Item 33.
Yes.
Item 33. Your I is.
Disposed. Now IA is disposed.
I is disposed. No,
Yes.
I'm not on 34. I'm saying.
Yes.
Here I is 192.
Yes, my lord.
192.
Here in this is also the stay application filed, and
Here also
it
stay
also
application
covers.
file. Here the 180, 192.
Yes, my lord.
The 192 is
Serial number
item-
3.
Serial number 3.
Yes, my lord.
192 is serial number 3. Again, you don't have any objection here? Similar order? Here also it will be same order, but the execution case number here, the date of order is also same, 11/09/2025, passed by the learned first step court, so and so are all same. Only the execution petition number is 04/2025. And the amount is half of the amount, that 50% I have already told, na? That 50% will be out of
70,
30,
80.
no? No,
Your
no,
lordship-
no.
your lordship will come-
192, it is
Yes.
31 lakhs, 26,726. Isn't it?
Yes, madam.
31 lakhs 26,726. That is the amount. Otherwise, all the order will be same kind of order. And stay will be there till disposal of RFA, connected RFA 50/2025. With the same observation, both the petitions are disposed of. Same order will be there. Only the execution number and the amount will be different. And out of which 1 crore has already been deposited, that will be for connected all 5 numbers of LA. Just show me afterwards, sir. So the amount of 31 lakhs 26,726, 50% has already been deposited. As per the earlier order, same order will be there. Only the difference is the execution case number. Okay.
Much obliged.
These two are disposed of. Huh?
Item 32, please.
Just tell us one thing. This hearing list is for only for Tuesday. No? For the whole week. For the whole week. I have some personal problem today. So some are being adjourned. Now see 1, 6, 7, 9 and 10 has already been adjourned. There are others and they have approached you for hearing.
I think today no councils are here for representing
Okay.
cases. So we can just...
Okay. Because I have some, my mister is going, that's why I'm just.
May it please your lordship.
Yes, it is a bail application.
My lord, this bail application pertains to an offence under the NDNPS Act.
Huh.
My lord, I have also gone through the TCR as well, and on the perusal of the TCR, it is very apparent that there is even no substantial compliance of the constitutional safeguards guaranteed by the Constitution of India, specifically Article 22.
What are the complaints you are saying?
Non-compliance of Article 22 is, in the sense, grounds of arrest was not furnished.
That is the 47.
Yes, my lord.
47, 48 are not complied with.
My lord, that is one of my grounds. My lord, my grounds, they are mainly two. Firstly, since this case falls under the intermediate quantity, I have been charged under Section 21B of the NDNPS Act.
It is of intermediate quantity.
Intermediate quantity, so therefore, the rigors of Section 37 of NDNPS Act does not attract here. And secondly, my arrest is vitiated due to a violation of the constitutional safeguards under Article 22 of the Constitution of India. To be specific, I was not furnished the grounds of arrest as mandated by Section 47 and Section 48, and also mandated by the law laid down by the Honorable Supreme Court in Prabir's case, Vihan Kumar, and recently in Mihir Shah's case. Now, even Your Lordship herself had last year, during the month of, I believe, October, had made a lengthy observation in this regard in bail application 2282 of 2025. Your Lordship herself had also discuss that aspect. I want to bring that onto the notice of this court because the facts of this case and in this bail application, they are very identical but different in a way that in this, my bail application, the offense is section 21B. Now, if I may take you firstly, my lord, to the brief facts of the case. My lord, I was arrested on 7/4/2025. 7/4/2025.
You got arrested?
Yes, my lord. For an alleged possession of 22.9 grams of suspected heroin. And allegedly, as per my alleged confession, another co-accused was arrested on the same day. And from him, 142.46 grams were recovered from his residence. And these separate seizures, they were clubbed together into one. And so, therefore, we became co-accused in one same case. Subsequent to that, Lordship, on 5/6/2025, charge sheet has been filed.
Okay, CS5.
Yes, Lordship. And subsequent to that, consideration of charge has been conducted, and to which I pleaded not guilty, and I claim for trial. The prosecution cited 8 witnesses, and so far trial has been going on.
So out of 8 witnesses, is there any witnesses already been examined?
Yes, my lord.
How many?
To my knowledge, I believe 3 or 4, my lord.
4.
My lord. 2, 3, 4. During the time of filing this bail application, Lordship, 4 witnesses have been examined. And on 30/10/2025, I had submitted my bail application before the Honorable Trial Court, and it was rejected via order dated 30/10/2025. And I have raised all these things which I have raised herein in this Honorable Court, but the same, they were not considered. Aggrieved Lordship, we are before this Honorable Court today. Now, to elaborate on my grounds, Lordship, I believe your Lordship is very well aware of the fact that since if Section 37 of the NDNPS Act is not attracted, that means we will have to be governed by the normal bail jurisprudence.
No, but you are saying that 37 is not attracted now, but
Correct.
clubbing these seizures, it is of commercial quantity.
No,
isn't
my
it?
lord. Still, it's
Even,
still not.
even if after clubbing,
Yes, my lord.
it's not commercial quantity.
It's not commercial quantity.
Okay. Then. In which section these are 21B and then?
21B
Is there 29 is also there?
Yes, my lord. 21B and 29(1) of NDNPS Act.
So as a whole, it is a commercial quantity or not intermediate quantity.
Intermediate quantity still, regardless of being clubbed together. But it is my submission that clubbing of this is impermissible. That is one of my contentions before the trial. But that is an altogether different thing before this Honorable Court. Now, my lord, your Lordship is very well aware of the fact that when Section 37 of the NDNPS Act is not attracted, the rigors of this section is not attracted, that means we will have to be governed by the bail jurisprudence, which is one, the state has to show the necessity of my incarceration in jail. And number 2, we will have to consider whether I am likely to jump bail or not, and whether I am likely to influence witnesses. It has been laid down by the court so many times, Lordship. Even in Sanjay Chandra's case, the Honorable Supreme Court had said that necessity is the operative test. I'm just showing this citation.
Which para you are relying here? Which para you are relying?
2012 1 SCC, para number 22.
22.
If I may read, my lord.
Hmm.
Para 22.
Yes.
From the earliest times, it was appreciated that detention in custody pending completion of trial could be a cause of great hardship from time to time. Necessity demands that some unconvicted persons should be held in custody pending trial to secure their attendance at the trial, but in such cases, necessity is the operative test. I will read up only till that, Lordship. So it is very clear, even Lordship herself knows very well that in cases like this, they have to show why it is necessary for me to be in jail. And another reason, Lordship, is that I am a manual laborer. My incarceration in jail have made the livelihood of my relatives detrimental. And I have been incarcerated in jail for around 9 months now, Lordship. And I have already stated that so far 4 witnesses have been examined out of 8. And the rest of the witnesses who have not been examined, they are, I believe, so far all of them are government officials. So there is no chance for me to tamper with witnesses or evidence. All the witnesses, all the evidences, they are already there in the custody of the state. Charge sheet has already been filed. Everything has been recorded. They even stated that AV recording has been done. So there is no chance for me to tamper these evidences at all. So that is one of my main ground, number 1. And regarding the violation of the constitutional safeguards, my lord, I believe your lordship is, as I have stated out earlier before, your lordship is very well aware of the judgments laid down in Prabir, Vihan Kumar, and recently in Mihir Shah. Now, if I may take you to lordship, the grounds of arrest which they have stated, page number 37 in my bail application.
Yes.
Lordship has got it. Lordship, this page number 37, although the title says, the name of the document says grounds of arrest, it is not in compliance with the law laid down by the Honorable Apex Court. Because this format is in a template style, certain placeholders are there. It is not specific upon the accused. So this is not what the law have, the Supreme Courts have laid down. This is very similar to that bail application I have cited earlier, Lordship, in bail application 2282 of 2025. If I may read, my lord, para number 12. Lordship has got it. Para 12. After hearing the submissions made by the learned counsels for both sides, I have also perused the case record and the annexures filed along with the petition, more particularly the notice issued to the present accused petitioner under Section 50 of CRPC. It is accordingly seen that while issuing the said notice, though the name and the address of the accused petitioner, along with the case number as well as the sections under which he was arrested are being mentioned, but admittedly there is no mention about the grounds of arrest in the notice. Thus, it is the admitted position that the grounds of arrest were not intimated to the accused petitioner or to his family members at the time of his arrest, which is a statutory right of an accused, and it is also a constitutional mandate that the person should be intimated regarding the grounds of arrest under which he was taken into custody of police. It is the contention of the petitioner that non-communication of the grounds of arrest is in violation of Section 51 of CRPC, corresponding to Section 47 of BNSS, rendering the arrest and subsequent remand of the accused petitioner invalid. The accused petitioner has the fundamental and statutory right to be informed about the grounds of arrest in writing, and copy of such written grounds of arrest have to be furnished to arrested person as a matter of course and without any explanation. Non-supply of written grounds of arrest to the arrested accused petitioner would vitiate the arrest, even if the case has been charge-sheeted. It is evident from the memorandum of arrest issued to the accused petitioner that it mentions the recovery of the contraband and states that there is a prima facie case against the accused petitioner under Section 8C. Now, this is very similar with us, Lordship. Read with Section 22C and 29 of the NDNPS Act. However, it is a fact that there is no specific mention or detailed description of the alleged offense committed by the accused petitioner. It is also an admitted position that Section 8C of the NDNPS Act comprises various types of offenses, but the memorandum fails to specify which particular aspect or sub-offense under Section 8C is being invoked in the present case to attract the application of Section 22C and 29 of the Act. In para 16, Lordship, in the instant case also, as discussed above, it is seen that there is no mention of grounds of arrest in the notice issued to the present accused petitioner under Section 50 of the CRPC, and except the name, address, and the case numbers, there is no mention about any other particulars of the offense as well as the grounds of arrest. So from the proviso of Section 50 of the CRPC, it is seen that there is clear violation of mandate of Article 22(1) of the Constitution of India, and in such cases, in spite of the statutory restrictions under Section 37 of the NDNPS Act, this court is of the considered opinion that for the violation of the Constitution mandate contained under Article 22(1) of the Constitution of India, the arrest of the petitioner is vitiated, and that it may be a sufficient ground to consider his bail application in spite of rigor of Section 37 of the NDNPS Act, which provides the restriction in granting bail in the cases of commercial quantity under the NDNPS Act. Now, my humble submission, Lordship, is that this Honorable Court may hold a parity view with respect to this principle laid down here in this bail application, Lordship. And there is also another stark non-compliance of the supplementing this Section 47 violation, Lordship, because the state government, the government of Mizoram, had issued a notification supplementing this in this respect, Lordship. If I may take you to page number 96. Annexure number 5.
Yes.
Lordship has got it. Yes, sir. So, Lordship, to the best of my knowledge, I think this is this notification has been issued, supplementing the mandate of the Article 22, Section 47 of the BNSS. If I may read.
Your petitioner got arrested when?
Lordship?
2025. Your petitioner got arrested in year 2025.
Yes, yes, Lordship. On
notification
7/4/2025.
Oh.
In the interest of public service and as envisaged under Chapter 536, Section 36B of the BNSS 2023, the government of Mizoram is pleased to notify that every police officer making an arrest shall prepare a memorandum of arrest, which shall be attested by at least one witness who is a member of a family of the person arrested or a respectable member of a locality where the arrest is made, countersigned by the person arrested. Now, let's suppose and assume, Lordship, for the sake of argument, let's assume that these grounds of arrest, regardless of all those judgments, is acceptable, just for the sake of argument. If we see and look at this document, it only appears to be acknowledged by the accused person himself, handwritten. But the government of Mizoram specifically says that it should be attested by at least one witness who is a member of a family. If the member of the family is not available, then it should be attested by a person of a respectable locality where the arrest is made. Now, there is no document in that regard, Lordship.
No, it is most probably in connection to 36 of BNSS, wherein it is made compulsory that in Article 36, when the arrest memo was issued, not only the accused but one family members has to be put their signatures. That
Correct.
is the issue on 36 BNSS most probably.
Correct.
So that in that context also that notification has been issued. Anyway, okay then.
Correct. Here in Mizoram Lordship, excise personnel used to write memorandum of another memorandum of arrest. If I may take you to the relevant document. Seizure, it's named seizure and arrest memo. I've annexed a typed copy in page number 30. I think this is in respect to section 36.
30.
30, Lordship.
No, this is to seizure, I think.
Yes, seizure and arrest memo.
The arrest memo is, I don't know.
Perhaps this is a different thing, Lordship.
Anyway, it was also, it is written that the arrest information was conveyed to so and so, the wife of the accused, through mobile number so and so. The
Yes.
recorded was also done during the making the seizure
Yes.
and arrest.
That is how it appears.
Okay.
That is how it appears, but that stipulation therein and the separate grounds of arrest, they are different. Now, the reason I'm showing this, Lordship, is just that we want to come honestly before this court. These things have been done, but in spite of these things, the mandatory provisions are not complied with. So that is the reason why I have shown this document, Lordship.
No.
Overall, Lordship, if we may be allowed to be released on bail based on these grounds, and if I may be allowed to rebut the submission of the learned PP.
Yes.
I'm deeply obliged.
Now that the TCR has arrived, I have gone through the grounds of arrest. In this case, my lord, the bail applicant was caught red-handed while trying to sell heroin. And on his version, my lord, the real owner, I mean the owner of the heroin, was also arrested. And on the arrest, my lord, they have been given the grounds of arrest as per mandate of the Constitution. Your Lordship will see the grounds of arrest. Yeah, my lord, it has been clearly stated that...
Where? Page number?
Page 37, my lord.
Yes, 37.
Page 37.
Mm.
I, Zoming Liana, Inspector of Excise and Narcotics, do hereby inform you that you have been arrested on this 1:45 p.m. of 7/4/2025 for sale, possession, abetment, consumption of narcotic drugs in violation of Section 21B of NDPS Act. In case you are arrested for a bailable offence, you are entitled to be released on bail. Grounds of arrest and right to bail has been explained to you in the language known to you. So, my lord, this was given to the bail applicant at the time of his arrest, and his signature was also taken, my lord. So, the grounds of arrest was furnished to him as per the compliance, my lord. as of now, trial is going on. And out of the 8 witnesses, my lord, this petition was filed in last year. 4 witnesses have already been examined. And by now, maybe, my lord, other witnesses are also examined. I'm not sure of the number. So, my lord, and since the petitioner was arrested for selling of heroin, my lord, his incarceration in jail is badly needed because it's a hindrance to the society. So, his bail application may be rejected at this stage.
Lordship, if I may kindly make some small rebuttals. Not so much of rebuttals, but short replies. Firstly, it is my humble submission that regardless of the trial going on, it should not be a reason why the applicant should not be granted bail, firstly. And secondly, since his arrest is vitiated, Your Lordship has also rightly held that the filing of charge sheet or the trial going on that does not differentiate things. That should not matter. And my involvement, whether correct or not, Lordship, that should be determined at the time of trial, not at the time of bail, Lordship. And I undertake to comply with the directions of this Honorable Court, and I also undertake to appear regularly at the time of trial, if this Honorable Court grants me bail, Lordship. I'm deeply obliged.
Hard Mr. You are Mr.
Elgin Zothan Moya.
Hard Mr. Swenso, the learned counsel for the petitioner, and also heard MS Swenso, the learned. You are appearing as a PP here.
PP, madam.
PP, State of Mizoram, Swenso. This is an application under section. You can write the sections and all from the court. Section so-and-so in connection with so-and-so. Next para, scanned copy of the TCI has, along with the case diary, has already been received. Where is the same? Next para, it is submitted by Mr. So-and-so, the learned counsel for the petitioner, that the present accused petitioner, is you're for one petitioner only?
One petitioner only,
Petitioner, and petitioner is innocent and has not committed any such offence as alleged in the FIR. Further, he submitted that there is no compliance of section 47 and 48 BNSS, which violates the principles of Article 22(1) of the Constitution of India. At the time of issuing the notice, except the name and sections of the case number, there is no detailed description of the offence alleged to have been committed by the offence, nor there is any grounds of arrest specifically mentioned in the arrest memo, in the notice issued under section 47 as well as 48 of BNSS. Mr. So-and-so further submitted that the case is of intermediate quantity, and as per the allegation, the accused was arrested. The accused was arrested while so and so, and as per the allegation, some quantity of heroin was seized from his possession, and on the basis of his statement, another co-accused has already been arrested, from whom also some quantity of heroin was alleged to have been seized by police. First, accused got arrested in connection with this case on 4/7/2025, and since then he is in custody. First, case has already been charge sheeted on 5/6/2025, and out of 8 numbers of cited witnesses, 4 were already been examined by the prosecution. Mr. Swenso further submitted that the remaining 4 witnesses are the official witnesses, and hence there cannot be any question of hampering or tampering with the evidence of the remaining witnesses. Full stop. Next para. He further submitted that as the case is registered under section 21B/29(1) and the PS, which is of intermediate quantity, and hence the rigor of section 37 and the PS will also not follow in the present case. Referring to the state notification dated dated 27 June 2024, it is submitted that the state of Mizoram has already issued notification with a direction to the arresting authorities to arrest any person. While arresting a person, one attested in presence of arresting a person, while arresting a person that and at the time of issuing the arrest memo, at least one witness attested, at least signature of one witness has to be there from a family member or a person from a respectable of a person of a respectable person from that locality, which has to be countersigned by the accused itself. But from the notice issued to the petitioner under section 47 and 48 BNSS, as well as from the arrest memo, it is said that there is no such compliance as required under section 47, 48, as well as 36 of the BNSS. Mr. Swenson, next para. Mr. Swenson further submitted that the accused is a daily wage earner, and there is none to look after his family, and that apart he being a permanent resident of his address locality, there is no probability of there's no ground there's no chance of absconding, even if the accused petitioner is granted with the privilege of bail. Mr. So further submitted that as the rigor of section 37 is not attracted in the present case, it will present case the only ground for detaining the accused petitioner. You are referring to item para 22, na? Here.
Sanjay Chandra, Lordship. Para 22, Lordship, yes. Correct. Necessity is the operative test.
submitted that the necessity is the operative test. Test for detaining a person. I will make a sentence. Wait. If there is any correction, I'll do it. Necessity for detaining a person after. I don't know what sentence. You just tell me sentence first. Sentence. Attractive. Necessity of the in only the necessity is the operative test. In that next para, in full stop. In that context, he also relied on a decision of Honorable Supreme Court, reported by 2012. 1 SCC is 40. Sanjay Chandra versus so and so. I'll give you this here. I'll give you this one. And basically emphasized on para 22 of the said judgment, which read as under. You make so and so, huh? Next para, he further submitted that there is, as from the notice and the arrest memo itself, it is seen that there is complete violation of Article 22(1) of the Constitution of India, and as per the guideline made, as per the guideline passed in Honorable Supreme Court in cases of Bihan Kumar, bracket of Supra, as well as in Probirbur Kayastha, the grounds of arrest has to be communicated to the person concerned who is arrested, and the family members of a person is also to be intimated the ground of arrest. In written, there should be a written communication, written communication of the ground of arrest, so and so. Citing the above referred judgment and considering and accordingly it is submitted that considering the above on the ground above, the accused petitioner may be allowed to go on bail. However, he being the local person will provide sufficient surety and will abide by all terms and conditions to be imposed on him. First. Next para. MS so and so, the learned PP, State of Drum, submitted in this regard that the present accused petitioner caught red-handed while selling heroin, and on the basis of his statement, the co-accused the owner of the contraband was also got arrested in connection with this case. She further submitted that there is sufficient compliance of section 47 and 48 BNSS, and from the notice itself it is seen that there is the mention about the ground of arrest in the notice issued under section 47 BNSS. She further submitted that out of 8 numbers of prosecution witnesses, 4 has already been examined, and considering the nature of offence committed by the accused petitioner, his further incarceration will be required for the trial of the case. Accordingly, she raised vehement objection and submitted that the bail application of the present petitioner may not be considered at this stage. Next, after hearing this submission made by so and so, keep this, I'll give you to dictation in the chamber. I'll pass the order. Later part I'll give.
Deeply passion.
Oh, sorry. List of autos. List pull out. The hearing list will just make a mention. But we have to make any.
No need to call out. So far as the councils are not.
No, but still, is anybody just say that? Is anyone? No need to say.
One was fixed for today, but I think it has already been adjourned.
Which one?
Item 1.
How? Item 1 was there. It
Yes.
has already been adjourned and they prayed
The
for
rest, Madam,
listing
is
it on
fixed.
2nd of February.
Yes. The rest are fixed, so I don't think anyone is present today.
That's what I'm just asking him whether there is anyone.
Yes, madam.
Anybody is over?